city engineer.
Paul Lopes.
Jussier Lopes. Mary Teichel.
Louise McMahon, ex officio.
Greg Seaver, ex officio.
Thank you. Fareed, could you give us an idea of where we are at this project at this point?
Yeah, this is Concord Street, not to be confused with Concord Road, because we have two of them. We have an existing sewer on Merrimack Street. It's off of Lake Avenue area, okay? And the petitioner is a couple of houses from that intersection of Concord Street and Merrimack Street. We don't have plans, but I looked into our topo maps in the office, and it seems feasible, but you know, we advise the applicant that you need to hire an engineer to draw the plans and look into it, because it's not an easy one. You're butting grades, you're below the intersection, and might not be served by gravity. So your engineer will have to do some kind of a study.
Yeah, we were just trying to get an answer, yes or no, if it's possible. That's what we're looking for.
Well, at least
So we can know what to do.
At the moment, we do have a positive recommendation from planning, but again, that's contingent on your engineering drawings and everything being approved, and in accordance with the 8 steps is what we use to plan and execute.
Yeah, because our house is the first house on Concord.
Mhm.
So,
Is it this one or this one?
So is that your turn on the street?
yeah,
And the
so
one
we
in
show the street,
corner?
which this is actually part of Merrimack.
Right, so this is second
This is mine,
house.
yeah, to be there.
Okay.
I have a question through the chair. How many units is this? Is this a one-bedroom house with 4 units? Is this a 2-bedroom house? Is this the three homes?
Well, this is a one family with 3 floors.
Well, I'm saying, it
That's
says
4
4 units.
No, that's.
Well, that's
not
how,
my house.
this is how this was written out, and that's why I go by what I have in front of me.
No, 4 units?
It says total number of units, 4. That would mean 4 departments as far as
No,
I'm...
it's a one family house, how can I have 4 units?
That doesn't say this, that's why I'm saying.
Oh,
that,
four
yeah.
that's wrong
It
then.
says single okay,
Four
so,
bedrooms?
what is it, 4
Yeah, 4
bedroom?
bedrooms.
4
Oh,
bedrooms?
him,
Yeah.
he 4 bedrooms.
Okay, 4 bedrooms. Okay. Thank you.
Any other discussion?
And just, you know, I make my recommendation to accept the project with 8 steps, with the understanding that you might not be able to serve it with gravity. You might need to go to like a low pressure pump.
Yes.
Okay. That's all.
Okay. I'd like to make a motion to approve the application for sewer at 3 Concord Street, providing with the 8 steps, but they have to, with the 9th step being that they have to hire an engineer, and the engineering plans have to be okayed by the city, and then they can go on with it.
Okay, I just have one question.
Sure.
That's when there's a motion.
Okay, I'll second that.
Okay.
I'll ask for further discussion.
Yeah.
Go ahead.
Okay, I talked to, I guess, before I even decided, they told me Pembroke, they said you guys deal a lot with Pembroke.
Mhm.
He told me that what I'm asking for first is a city line extension. Is that what we're talking about?
Correct.
Correct, okay, that's all I want, make sure that we're talking about that.
Mhm. Okay. Any further discussion?
Yeah, just want to clarify that the process over here is what we call the extension, but to approve the whole process, you need to hire an engineer to draw plans, not just a plumber.
So I would have to spend money before anything,
Correct.
but it's approved though, is that what you're
No.
saying?
No.
No.
No,
No.
we only look here, if I may, through the chair,
Sure.
just a feasibility that you can do it or you cannot do it. But you still, we have 8 steps, and I'll be more than happy to give you a copy of that 8 steps.
Yeah, nobody gave me that.
Yeah, and I don't have it with me. I can go down later on and give you a copy of the 8 steps.
Because what I was looking for first was an answer, yes or no, if I can do it. Because everybody said that I had to go through this process. That's what the meeting was all about, to see if I can hook up to the city or not.
Before we spend
Nobody
any
said
money,
yes or no.
Right, but
We can't say
we
no.
don't.
We can't say yes or no. until you follow the steps. And the steps is that you have to
Yeah.
hire an engineer, and your engineer has to come in with the plans. The city has to okay those plans, then you can, then they're gonna give you the yes or no's.
Yeah.
We're just approving that you're gonna hire an attorney, hire an engineer, you're gonna follow the that which would, and then if you're gonna be putting the sewer in, you're gonna follow the 8 steps that the engineer tells you that you have to do, if you can do it.
Then after that, we have to come over here again and show you?
No.
No,
Oh.
you have to go to, you just have to go to engineering
Engineering.
and show engineering your plans.
Yeah, because we don't have anything here, because we didn't know that we're supposed to have a plan,
Yeah,
you
no,
know?
they
Like,
cannot-
someone just called us, I don't know her name,
Mhm.
before yesterday, you know, and it was too late to, you know, do it,
Yeah.
so we're gonna
When I
find
came
out.
here and asked, they should have gave me the 8 steps. And I would have been all set.
Yeah.
No, the 8 steps wouldn't have helped you. No, the 8 steps would not have helped you. You have to hire an engineer.
Yeah,
That
but
is
how would I
given-
know that?
Because they should have, because this is why we're telling you.
Yeah.
Because Fareed would have told you, you have to hire an engineer. And he did talk, did you not talk to
No,
the
I never
man?
seen this man in my life.
The secretary.
Who are you,
Secretary
excuse me,
did.
Pauline,
I have some-
who are you
some
talking-
woman-
who are you talking about?
Some woman downstairs in zoning, and she didn't even know how to look at the zoning maps.
All right,
So,
okay. All right, so why don't you go ahead and get your paperwork in order. Fareed, would you give
I'll
him a
help.
copy of the
Yeah.
8 steps and shepherd him through the
Yes, I will.
process, and we can move this thing along?
yeah, I appreciate it.
No problem.
All right, any further discussions? Okay, Pauline, I second your motion. All those in favor?
Aye.
Okay,
I'd like to make a motion to
I'll
adjourn.
second that. All those in favor?
Aye.
Second that.
Okay, we're adjourned.
Thank you.
How you doing? Good, thank you.
Okay.
Thank you.
Actually, I want to go over the ordinance.
Do you have another?
Yeah, you want a copy
Dan?
of
That would be great.
I heard today that.
Is this the old one?
This is my proposed revisions, the highlighted, additions highlighted, deletions bracketed.
You need a copy of the other one, Lynn? Okay.
I cannot believe what is happening across this country with all the sex ordinances.
I know, isn't
I
it
mean,
something?
and look what happened in New Jersey. A kid raped a 5-year-old little girl,
Sure.
was given $15,000 fine, you know, to leave. No, not a fine, he was given $15,000 bail to go to, you know, $15,000 for raping a 5-year-old girl.
That
He
was
was
his
here
bail?
illegally. That was his bail.
Then we have to protect his documentations, package punches.
There's no train I called you, did you get that train?
I just saw the picture.
Listen to you. Mark said you're gonna put him out. He says, no, I'm only gonna give you 2 million.
Oh, for God's sake. Sounds like the dentist.
This is the microphone, so you can speak. There's literally pieces of that.
Good evening, I'd like to call the meeting to order. I am Mary Teicholz, chairperson. We have with us Pauline Basso and Dwayne Perkins, members of the committee. We have with us Corporation Counsel Dan Casagrande, Chief of Police Mr. Baker. We have Lynn Taversack, Greg Seabury, and Louise McMahon ex officio. I will read the request from Council President Cavo. It says, "Dear members of the Common Council, I am respectively requesting an ad hoc committee to amend the sex offender ordinance to eliminate the zone hopping concern that was discussed at the December meeting. In addition, I am also asking that the ad hoc committee address any other issues and concerns that may arise as the city begins to implement the ordinance. Thank you for your consideration. Sincerely, Joe Cavo, Council President." So I'd like to ask Mr. Casagrande what what he found within the ordinance and what has been changed in the new draft we received tonight.
Thank you, Madam Chair. What I've put in front of the committee is copies of proposed revisions to the ordinance. The proposed added language I've boldfaced, and the deleted language I have put in brackets. And I just want to do very few changes, but I want to go to the change that was requested by Mr. Cabo first. That's on the last page of the ordinance. On the floor of the council hearing, it was brought up that there was a potential flaw in the way the ordinance is drafted was written. As written, it said that if a police officer encountered a sex offender in a child safety zone, as defined in the ordinance, then that person is to receive an infraction, a warning. And then, if that person refuses to leave or is later found in that child safety zone, then that person receives an infraction. And it was pointed out that basically would not prohibit an offender from, say, going from Rogers Park, getting a warning there, and then being found on Candlewood Beach Town Park the next day. And the council felt that the warning that the offender should stay out of all child safety zones should suffice so that the next time that person would be given the infraction. So we've added the language on the last page, the boldface language that says if the person refuses to leave or is later found to be in the same or any other child safety zone, the penalty set forth in this section shall apply. You want a copy, Paul?
Sure.
Excuse me, Paul Rotella entered also from ex officio.
Just the other changes you see on the first page, where I did just a little bit of house cleaning. I put the whereas clauses that were in the original ordinance, I just turned them into a statement of legislative findings and purpose. The language is exactly the same as in the original ordinance. I also, on the second page, I made a few changes to the definition of child safety zone. One, I added the term school because under the current ordinance, schools would be included in a child safety zone definition even though they're not expressly named, because all schools are on property on which there is also a public schoolyard or park. And so I just wanted to make that crystal clear that a public school is included within, that is the school building, is included within the definition. The second set of changes I made were in response to some comments that I got from the ACLU. You will recall in December when this ordinance was first being kicked around, the ACLU went public and said that the whole thing was unconstitutional. And so I, with the mayor's, at the mayor's direction, reached out to the ACLU and asked, for whatever comments or suggestions that they might have, because as I've said, the goal here is to not only protect our children, but to make sure that we're not infringing on constitutional rights. Unfortunately, they did not get back to me until long after the ordinance was adopted, but they finally got back to me in June. They still think the ordinance is unconstitutional. I disagree with them in almost all respects, based on my research. But there were a few points that they made that I thought were well taken. One of them was that the way the definition currently reads, it says any park, school, etc., which is under the, quote, jurisdiction of any department of the city. The lawyer that I spoke with indicated that, well, that could be determined to be very expansive. What property in the city of Danbury is not under the jurisdiction of the police department, for example? So they thought that that was capable of a more expansive meaning than we really intended. So I changed the word jurisdiction to ownership, to make clear that it's properties that are owned either by the city of Danbury or by under the title of the Board of Education, to try to eliminate that potential vagueness argument. The other addition that I made is on the bottom of page 2, and let me just read it quickly. It says child safety zone includes any and all buildings, land, parking area, or other improvements located on the same parcel on which each of the aforementioned facilities is located. And you'll recall, I said that was the intent of the original language. This just makes it clearer. But does not include any public street, and also does not include any public sidewalk which is located on the outside boundary of a child safety zone. I put that language in there because one of the arguments advanced by the ACLU was that this ordinance, because it prohibits entry into a public park, infringes on First Amendment rights. A public park is traditionally considered a quintessential public forum for purposes of exercising First Amendment protected conduct or actions. However, when you're dealing, and I won't bore you with a lot of constitutional law, but I think it's important to understand why I believe that this ordinance does pass muster under, even under the First Amendment. And by the way, no other court in the nation has addressed a sex offender ordinance on First Amendment grounds. So we don't have a ruling one way or the other. But when you're dealing with what's called a content-neutral regulation, which this is, in other words, this is not a regulation that says you can't go into a public park because you're going to say this. All right, that would be a regulation that says you're prohibiting something based on the content of what you're going to say. If that were the case, then this ordinance would probably not be constitutional, because that's a direct prohibition on speech based on the content of the speech. That's what the First Amendment is directed at. This regulation, however, is a content-neutral regulation. It basically says if you're a convicted sex offender, you cannot enter the park. It doesn't say you cannot enter the park because you're going to say this or say that. It's just it's a prohibition. So a court would view that as a content-neutral prohibition. For a content-neutral prohibition, an ordinance will satisfy First Amendment scrutiny if it does a couple of things. One, is it narrowly tailored to advance the governmental interest? In my opinion, the answer to that question is yes. What narrow tailoring means in the parlance of the courts is basically, does this ordinance accomplish the goal more effectively than if we didn't have the ordinance? Well, okay, the goal is to keep convicted sex offenders away from children in places, public places. Does this prohibition advance that goal? Certainly. So in my opinion, it advances the narrow tailoring test. The ordinance also, in order to survive First Amendment scrutiny, has to leave open alternative avenues of communication, reasonable alternative avenues of communication. So in other words, it's an ordinance is a so-called time, place, and manner restriction, which says you can't restrict what the person is going to say, but you can restrict where they're going to say it. So what this amendment does is it makes clear that a public park does not include a public street that is adjacent to the park, and it doesn't include a public sidewalk that is on the boundary of the park, so that any person, whether he or she is a sex offender or not, who wants to go into, for example, Rogers Park and walk down the street or be in a parade or listen to a speech that's being given in, where the grandstand is, usually on Memorial Day, can participate in that event, can stand on the sidewalk, can hand out leaflets, can make any kind of expressive activity, including advocating the repeal of the sex offender ordinance. It says what this amendment basically makes clear is that, yes, you can't enter the park as defined, but you certainly have ample alternative ways of expressing First Amendment rights, because you can do it right next to the park, and you can also do anything that any other person could do in a public street for First Amendment purposes. Then I just I added following additional language, and this is where I need to get back to you, because I thought it would be a good idea, again, just for purposes of notice to sex offenders as to where these places are, that we should have a list.
Yeah.
Because some people might not think of, let's say, Elmwood Park or Kennedy Park. Those are public parks, and they are included within the penumbra of this ordinance. But in the interest of giving reasonable notice to a person who would be subject to this prohibition, what we've asked, and the mayor has asked Sean Hardy to do, is to basically get us a list of all the child safety zones in the city, with assessors, lot numbers, et cetera. And when I get that list, and it's been, in fairness to Sean, it's been difficult for him to do that, because a lot of these parks are, they're just amalgams of all these different assessors lot numbers that have been, acquired by the city over the years. So it hasn't been an easy task for him. When I get that list, one of the things I'm considering coming back to you with and recommending is that instead of having this big, long, 3-page cumbersome list in an ordinance, one alternative would be to say, in the ordinance, that, the director of planning or the zoning enforcement officer shall compile a list, put the list on the city's website, and keep the list current, so that it's a way to give notice to people who are affected by the ordinance. I haven't made that determination yet. I need to talk with the planning director about that first. But one advantage of doing it that way is that, if you put everything in an ordinance, the only way you change it is you got to change the ordinance. This way, if there's something, a new part comes on, you just change the list and change it on the website. So that's the purpose of that revision. The last revision is on the third page. It is to subset. I've added a third exception to the ordinance. You see under section C, three little I's on the third page. It basically says the ordinance shall not apply to the extent that the conduct prohibited by this ordinance is in conflict with any sentence or order of probation or parole imposed upon a sex offender. The reason I thought that was a good idea was I gave I moderated a seminar early this year that was held by the Connecticut Association of Municipal Attorneys, and the subject of the seminar was this type of sex offender ordinance, which has been attracting national attention. And one of the comments by a couple of the attorneys in the audience, and actually the chief probation officer of the state attended the conference, and they said that the concern they had was with someone who, let's say, is a relatively young person, hasn't completed his high school degree, and oftentimes that person will, as a condition of probation or parole, they'll order the kid to go back and get his education, complete his high school education. The way it was drafted, the way it is drafted now, that person literally could not enter into a Danbury public school in order to accomplish that. So this language makes clear that if you're under an order to do that and complete your education, the ordinance does not apply. So those are the changes.
Okay, thank you. Chief, do you have anything you would like to add?
No, the only concern the police department had was the first issue Mr. Casagani addressed about the same or any other child zone, and that is correct in the ordinance. That's really the only problem we had with it.
Okay. I'll take questions from the committee first, and then I'll take questions from the ex officio members. Any questions from the committee?
I have a question. Through you, Madam Chair, Attorney Casagrande. Would the ice arena include a child safety zone?
The ice arena isn't owned by the city of Danbury. No, it's under private ownership, so it would not be within the definition.
One follow-up, please. I'm not sure exactly who it would go through, probably Chief Baker. During that one of the last meetings that we had concerning this ordinance, we did mention something about notification of the violation to a parole or probation officer. I don't believe any of that wordage is in here.
We did talk about that, and I would support that. That'd be a good idea. The better we communicate back and forth with probation, the better we serve the community. Yes, that would be, I think, a worthwhile addition to the ordinance.
Thank you.
Mrs. Bassel.
Okay, after the chair, Corporation Council, could we raise the fee to equal the state's?
I mean, fine.
The fine, yeah.
Last
What
I
is
checked, this was the state maximum. I don't know if it's been amended in the last 6 months, but when I drafted this, I looked at the state.
I'm not sure, but I thought that I had seen that the first offense was, I guess maybe, I know there was 25 years. Like the second offense is 25 years, and the first one was 25 years, the second one was life.
You mean for sex offenders, convicted
Sex
sex?
offender.
Okay, but this is a civil ordinance that comes under the infraction
Okay. Okay.
authority of the city, and there's a limit to the fines that you can issue for
Okay.
infractions.
And another thing, Dan, is that what bothers me is where you read where the sex offenders, there's some of them that are like 1 or 2 living or 3 living in the same house. Is this anything that we can do or we can't do? We can't touch that.
This ordinance does not address that issue
Yeah.
about residency restrictions. I mean, when we first proposed the ordinance, remember, we talked about there's 2 ways you
Yeah.
can do it. One was the residency restriction. In my opinion, the residency restriction is less effective. And in fact, there's law enforcement literature out there that says what these residency restrictions actually can have a counterproductive effect by forcing these people underground and avoiding registering or doing what they need to do. So, some states have done it, some towns have done it, but and again, this is a policy consideration. I think you could reasonably determine that the simply keeping them out of places where kids are likely to congregate is going to be more effective than a residency.
Yeah. Now, can I continue?
Sure.
Another question is, someone had mentioned the homeless shelter. We have both female and male sex offenders, but I mean, and sometimes we have, is there anything we can do about that, or just don't include that with this?
I would suggest not. The answer is I don't know enough about that issue to give you competent advice on it at this point. I do know that Les Pinter is looking into that question.
These are things that have just been brought up recently, and I mean, these are things that we probably wouldn't have even thought of.
Right.
But I mean, because there's so much out there today that everybody is just discussing this, and so many things have happened, and the fines, I mean, these guys are walking the streets. I mean, then we're finding that they murdered 3 college students, and this is it down in New Jersey. I mean, but I mean, this is just ridiculous, and that's why we've got to protect the children. This is our main goal in this, and that's to protect the children.
Mrs. Basso, the ones with the same address is the new street. It's the shelter. The people on the
Yeah, we
list,
looked
it
at
is the
that.
shelter, yeah. So that's why they have the same address for 3 or 4 people on there. And Mr. Perkins, the notice still is in the ordinance, it's under number 3. Did you not get the sheet maybe, or?
I thought that this notice was just notification that there would be this type of ordinance. I don't
Right,
think
it's,
this,
right, you're right. It's a notice to the sex offender himself or herself.
just that we're establishing
Right,
an
and
ordinance.
we did that in January. We sent out about 35 registered letters to everybody that was on the registry at that time. But what we were talking about
It's
is
different
that
from
in
this.
addition to either citing or giving a written warning that we, the police department, would send notice to the probation department that a registered sex offender was encountered on this time and this date at this location, so that the probation department can take any appropriate sanctions they have for the situation. Is what Dwayne and I discussed last time around.
Okay, I'll take Mr. Attelo first.
Thank you, Madam Chairwoman. Through the chair to Dan. My main concern the last time around, and I brought this up during the public hearing and also with the meeting, was continuing education for felons. But in particular, the felons whose offenses were not directed against minors. I'm not at all comfortable putting sex offenders, convicted sex offenders whose offenses were against children, back into school, regardless of how great an idea the probation officer thinks that is. And I was wondering, I'm comfortable enough getting this through now, but I'm wondering if in the future we could maybe target that a little bit more so that we achieve the same goal with a little bit less danger. I really don't want to see even a 17 or 18-year-old who went after a 3-year-old after he gets out 4 years later having an expansive probation officer say, it'd be a really good idea if you go back to high school. Maybe it would be, but maybe a correspondence course would be something better. On the other hand, I don't want to see a 45-year-old guy who was convicted for doing something against his 43-year-old girlfriend prevented from getting a degree or improving himself to some extent, or even a woman. You know what I'm saying here?
Yeah.
I mean, I'm comfortable enough with this as is. I'm glad that you've addressed it. But I am a little bit nervous about and I know we don't have too many sex offenders in Danbury, and we have even less who were convicted of assaults against very small children. So this is not exactly a pressing need at the moment, but it could be done. That's all it is.
One possible way to address your concern is that even all this exception says is this ordinance doesn't apply to the extent that it is in conflict with the order. So in other words, a lot of times the orders of probation will say you got to go get your GED. Now there are alternative ways of doing that, other than being physically present.
Take it, yeah.
And when you're done with your class, you got to get out.
And let's hope we don't have a justice system that's sending offenders against little kids back into schools where our little kids.
Right.
So let's, okay.
Right.
All right, thanks.
Councilman Seaver.
Thank you, Chairman. This is directed to Corporation Counsel. Dan, I'm afraid I know the answer to this, but I guess I just got to hear you tell me that. The public schools in Danbury are protected. The parks will be protected, but the parochial schools in Abbott Tech and Immaculate High School, we don't have any jurisdiction over there. Is that correct?
None of the ordinance that I've seen around the country have addressed the issue of private schools simply because it's private property. You have an issue, especially when you get into First Amendment issues about parochial schools. I've steered away from it for that reason, but the answer is yes, this does not apply to private schools.
Can I have a follow-up, please? What happens, hypothetically, obviously, what happens if St. Peter's School or St. Joseph's School, once this takes effect, they say, well, we'd like to be included in that. Can we somehow include them in that?
I would have the same concerns. I mean, I don't want to give you a drive-by answer to that, but you then get into the issue of making a state or local government making a law respecting an establishment of religion. There's a whole host of cases dealing with freedom of separation of church and state and those kinds of issues. So I couldn't begin to give you a cogent answer to the question of if a parochial school asked to be included, could we do it or not? I just don't know.
I guess I'm just grasping at straws. Can I have one more question, please? I applaud your efforts, Dan, to publicize the areas of the website. I think it's a great idea where it's ongoing. Good move on your part. But the thing that came to my mind when I heard that is, what if some of these people that are sex offenders don't go on the websites? I mean, then is there some other way, some other means of notification? I guess.
That's a good question, but that's what we tried to address in the original ordinance, and the chief or his designee is required to provide actual written notification to the sex offenders as they get on the list. So even if they don't have access to a computer, they're still getting notification from the chief of police, and the chief, through I guess Sergeant Williams, is monitoring the registry and the people who are living in Danbury periodically, so that as new people come on, they will get the notice by actual mail. But the fact that you haven't seen you haven't gotten the notice, or you haven't seen it on the website, it's not a defense to a violation, which we make clear in the ordinance.
Thank you very much.
Councilwoman Tattersall.
Thank you, Madam Chair. Through you to Dan. Dan, you took the word child out in 4 places.
Oh, that's right. Yeah, I forgot to mention that. I took it out simply because it was pointed out that not every person who's a convicted sex offender is under the Connecticut sex offender law has offended against a child. So I just wanted to make that clear by not labeling someone as a child sex offender in fact, their crime has been against an adult.
If I could follow up, then that means everyone on the sex offender list is prohibited from being in the child safety
Correct.
zone.
And that was the case under the original ordinance as well.
Can I ask a follow-up, please?
Sure.
I think you stated a good goal, keeping convicted sex offenders away from children. Do you know what the conviction rate is for offenses, sex offenses against children?
The conviction rate? You mean of people who've been arrested, what the percentage
Arrested
is?
and charged, because the people obviously on the list have all been convicted.
Right.
Do you know what the conviction rate is?
I don't. I do know from reading through some of the literature that the reported, the actual reported convictions are probably far less than the actual number of these types of crimes that are occurring, simply because the victims are fearful of coming forward in many cases.
And one additional follow-up question, not the conviction rate, but do you have any information about the reporting rate of crimes against, sex crimes against young children?
Not specific. I mean, I could go back to the literature, but I think my previous answer would probably apply by analogy that for every crime that's reported, there are a lot more that go unreported.
Thank you.
And that's not my opinion, that's based on the literature that I've seen.
Councilman Chin.
Thank you, Chairwoman. Again, to Dan, as I was going through this, on the child safety zones, as you know, I brought up several examples during the last time we met, several communities, and also on the dais. But as the city grows and we get more and more new buildings and authority over certain other venues, for example, at the Charles Ives Center, that will be considered a city park, that will be part of this zone?
If the city acquires ownership of
If
it,
the authority runs it.
Well, it would be like Terrawell, I think. Excuse me.
That's
I mean, similar to Terrawell, the Scott Phantom Museum, which is now being authority, with all that would be part of this,
actually, the way, with the change,
it would be.
no, I don't think it would, unless I'm missing something, because the change says that it's any park, let's just leave it at parks for the time, any park which is under the ownership of the city of Danbury or of any department, agency, or authority of the city of Danbury.
Authority.
So it's
Department.
ownership, but it's gotta be owned by.
But again, I mean, if we can better clarify,
I mean, that's a good point, Ben. I mean, if the intent is to, and perhaps under the way it's worded now, jurisdiction might be broad enough to include a Charles Ives Center or a Terrawell Park, but the change that I've made, again, in an effort to clarify exactly what properties are covered, means that a child safety zone is only something that's owned by the city or a city department, or, for example, in the case of the War Memorial or the Police Athletic League, that's leased by the city to another entity for the purpose of operating a park.
so, again, just to follow up, because I think I need to be better, I mean, it seems like everybody needs better clarification. The Terrawell Authority, that park, I guess, is owned by the authority, they manage the land?
That's the Terrawell Park Authority, which is
So
a
they'd
city
be
authority.
excluded from this, as then, what you're just telling me.
No, but this, I believe the city owns Terrawell Park, so
Yes.
yeah, no, this would be included.
So, but
Terrawell Park is included in the
So it's-
definition of the ordinance.
it's the physical ownership, so if you lease the property, that's not considered ownership, and therefore would not be part of this?
If the city leased a piece of property from a private person, correct.
Leased by the city.
So for
Well,
example,
but when I say leased, when you say leased in the ordinance, it means leased, in other words, the city is the owner of the property, but leases the property to a private entity.
so for example, I'm just using it as an example, just to get a clarification. The state of Connecticut owns Charles Ives land,
Right.
but the city does own, I mean, or not yet, it could be. But right now, the city leases that from the state, so that would not be considered ownership since it
Correct.
leases. So
Correct.
therefore would not be part of this.
Correct.
But again, I think
Unless you could change the language to.
But again, okay, that could be misconceived. If we can have it, properties that are physically exempt from this ordinance, from this thing, just physically list the properties that are exempt. So that could be, stop anybody that Charles Ives Authority is exempt from this ordinance.
You could, that's one way of doing it. The other way, that's why I thought that the idea of actually listing the properties that are included and actually having that list on the website, if the Charles Ives Center is not on the list, then.
Okay, so it's mandatory, if it's on the list, it's excluded, if it's not, it's not.
If it's on the list, it would be included.
Included, if
Right.
it's not. Just again, it follows, I'm sorry I'm taking so longer. Parking garages. We have Library Place and we have the one in Library. Is that considered part of this ordinance? I mean, they could hide.
It's just that,
City owns the garage.
right, but it's not a park or a school or a playground. So under the way it's written now, that
So
would,
they would be considered exempt.
correct.
And again,
Just because of the way the definition is worded.
Again, I'm just bringing it up so this is a record that we at least discussed it.
Mhm.
And then as a follow-up, again, as a recommendation to the chair, I know we talked about it before about the penalty, about the $100 penalty. If it could be a recommendation from the committee, to the council as a whole, to have Corporation Council draft a letter to the state reps to possibly to increase that fine to 500 to 1,000, whatever the committee sees fit. Again, thank you for that.
I just want to double check on that, because I think we did ask the mayor, and I think he was writing a letter to the state reps, inquiring about that. We'll follow up and double check to make sure that letter did go out, but thank you for the reminder. I have a question. Chief Baker, it wouldn't be a problem, let's say, about the notification that Councilman Perkins had talked about, to amend to include in here. That wouldn't be a stress on the police department to do that,
No, it
if
would
it
not.
were to occur?
No, we would
Okay.
support such a change.
Okay, great, thank you. Councilmember Tello?
Thank you, Madam Chairwoman. Through the chair to Dan again. Dan, under child safety zone, the way that I'm reading this, it looks to me as if the authority, the Charles Ives Authority, would be covered by your statute, by your ordinance. I mean, you're saying that anything that is under the ownership of the city of Danbury or authority of the city of Danbury, including but not limited to. I mean, you're saying it's, okay, if the city owns it or an authority of the city owns it, it's covered in the.
But the Charles Ives Authority doesn't own the property.
They run it.
They run it. They
State
operate it, but it's a state-owned parcel.
Is this possible to fix with a word? Can we insert a word in here to owned by the city of Danbury or an authority or controlled by an authority without necessarily having to own the actual property of the deed? I mean, for instance, we know we don't own the War Memorial, and it's not an authority. It's privately run, it's privately leased, it's a private organization. This doesn't apply to the mall. We don't own the mall. A lot of kids go there, but we don't own it, so we can't do anything about it. But the Charles Ives Authority, there may be a couple of other ones.
You could
Ricker
say
Park
under
is another example, yeah.
under the ownership of the city of Danbury, or any department,
Or controlled by an
or
authority.
which is controlled
Yeah.
or operated by
Yeah.
any such
Can
authority
we
or
do that?
department.
Is that, can you squeeze that in?
Sure.
Okay.
Yes, I mean, I think that would work if that's the council's desire.
Well, I don't know if it is, but I'm just
Yeah,
asking.
as long as, and that's why I think I place even more credence in the value of this list now, having a list so that there's no possible misunderstanding of what entities or properties are under it. But if you desire to extend it to a specific property, I don't think the key issue is, does it have to be under the fee simple ownership or
Right,
title of the
exactly.
city? If it's operated by the city, now let me just think about
Would you
that.
have jurisdiction over state land?
Yeah, that's the only thing as I think about it, it'd be
Well,
state
if
property.
it depends on the lease that we have with the state. I mean, if we can control the activities on that property, we might be able to do this. We're drawing a very fine point here with the constituents, with the voters, telling them that this part is a child safety zone, but this park, which is exactly the same, is not. It's really confusing. It's because the way we set the lease up originally and who owns the land and everything else, but we didn't think about this ahead of time. Can we take a shot and then work it out with the state later, or, I mean, it's up to you guys. I'm just saying that if we could fix this with language, if it turns out we can't do it down the road, then we can't do it.
I think, and again, I don't want to just speculate on this, I want to think about it, but I think if you were to do that, you'd have to have language in there that says that, you know, property that's leased by the city from another entity or operated by the city with the permission of that other entity in order for it to be effective, I think. I think that would be prudent language.
I'm sorry, did you? Okay. Councilman Chambers?
And I'm thinking through the chair, since that list you talked about, it's going to be very important, as you stated. Can that list be part of the ordinance itself as a section that we actually list the things? And then as a council, if we needed to add a piece, we can go back and amend this ordinance to add each list as it comes. So where the council and the city actually controls what it wants on the list.
Yeah, I was gonna say,
He
That
missed
would
the,
be-
he missed the.
Yeah, I think you read my mind, because that, before you came in, I discussed that issue of whether you want to make them all, put the whole list in the ordinance, or the other suggestion that I'm waiting to get the list from Sean Harry, just to see how cumbersome it is. Once I get it, one of the things that I'd like to discuss with you is the possibility of, instead of just putting a list, big, long, cumbersome list in the ordinance, just have the ordinance say that the director of, what's Sean's title?
CEO.
The CEO or director of planning, whatever, shall compile the list of the child safety zones, you know, with assessors lot numbers, so everybody knows, and shall publish that list on the city's website. And the advantage of that is that you don't have to encumber the ordinance with a long list. And then also, if there's another park that we add, the only way to add it to the list would be to amend the ordinance. Whereas if you just say in the ordinance, the city shall compile a list and the list shall be on the website, gives you much more flexibility in accomplishing that goal.
Just to get a follow-up, did you say the list could be available in the town clerk's office?
I was also going to suggest that it be made publicly available in the office of either the planning director or the town clerk or whatever.
Or at City Hall.
Or City Hall,
Yeah.
where, yeah.
Thank you.
Councilman Gaston.
Through the chair, to Dan. Dan, would like Elmwood Park have a assessor's number?
I don't know.
Because, see, this is what I'm saying, for him to have the list, and that's where, because like when you go up to the, we'll say like even the Mayor's Island out there, that's a park. There's
Yeah.
like little parks around, I mean, and.
It doesn't,
Right.
if there is no assessor's lot number, that's not fatal. It's
Okay.
just, in other words, the idea is to give reasonable
Right.
notice to people as to where this place is.
Okay.
So if Elmwood Park doesn't have a lot number, you just say, public park located on Main Street between Worcester Street and Center Street. You know,
Exactly.
that's all you
Thank
need to
you.
say.
Any other questions? Do you have
I don't have any questions.
I'd like to make a motion then. I'd like to make a motion to continue the meeting until Corporation Council receives the rest of the information we need, such as the list and the changes that, you're gonna be looking up and things like that. Like what Paul had asked, like the changes. But I'd like to continue the meeting for that reason.
So.
Are you
if I may-
saying, go ahead.
If I may, you're asking that the ordinance be amended to reflect Mr. Rotell's suggestions that property that's controlled or leased by the city also be included in this
Right.
with the owner's permission,
If you find out.
if that's legally permissible.
Yeah, and like information like the notice of the of the parole officer. Just a lot of little things that we brought up tonight. that you
Well, I
can-
just want to make sure we
Yeah.
have all that, though.
Right.
Right, the
Yeah,
notification
but-
to the probation officer if
Right.
someone is found doing fraud.
Yeah. So things we have to look at.
Okay. the notice would, in other words, the police department would be required to give notice of the issuance of an infraction to,
Even a warning, I would think.
even a,
Sure.
either a warning
Warning
or
or
an infraction.
infraction, absolutely, because they can employ certain sanctions that, through their system.
Mary, through the chair, would that have to be in the ordinance, or could that be a policy of the police
That's why we
department?
just want you to check.
I'd rather
that.
have it in the ordinance if it was up to me.
Now, there's no legal requirement that it be in the ordinance, but there's nothing that says you can't have it in the ordinance.
Is this, it has to be directly to the motion? Okay.
So, let me just make sure I'm clear on this. Right now, there's a motion on the floor to add some of the language that Councilman Rotella mentioned as far as leased land. There's also a motion to issue written warning citing violation of this ordinance. A copy is to be sent to parole or probation officers. That's where we are so far. Wasn't there something else as far as a list?
There's a list of the
That
parks.
doesn't have to be that's not part of an ordinance though, or
No, it's not gonna be
amendment.
part of the ordinance, but he still has to check to make sure that when he wants to make sure what Sean has it, we can see exactly what it entails.
Yeah, I'll be back to you with one of two things. Either I'll recommend that you put the entire list in the ordinance, or I'll have language that says in the ordinance that the planning director or whatever public official shall compile the list, make it publicly available in the appropriate city office, and shall cause the list to be published on the city's website and to be updated periodically as necessary.
Okay.
This actually does. Do we want to require the officer, under all circumstances, to have to notify the parole officer? Do we want to give the officer discretion?
I would not recommend discretion. I
No,
wouldn't
it's-
recommend discretionary enforcement because that gets into vagueness.
Not
issues.
enforcement, notification.
What's your policy reasoning behind that?
Accident, whatever. I mean, we've got a guy in good faith who's stumbling across Elmwood Park and he gets popped, and he's not hanging out there in the bushes. He's just getting a coffee, and
That's why.
next
that-
thing you know, he's up for 5 years.
That would argue for maybe waiting until he gets the actual infraction as opposed to a warning, because someone may innocently not be aware of the actual.
Okay, so are we gonna require notification for a warning or an infraction then?
That's up to you. It's up to the committee.
Okay, then that's, I think, something that needs to be thought about. Obviously, it's if the officer has, if I may, if the officer has decided this justifies an infraction, then it probably justifies notification. But if it's a warning, hey pal, get out of here, you're not, oh, sorry, I didn't know, you see him there the next day, then hey.
You made the motion to say
Maybe
infraction?
just say the notice will be issued
Then the
upon
notice
an
will be-
infraction.
Yeah, the notice will be issued upon infraction.
Any other discussion on the motion?
I think the fact that the officer is gonna issue a written warning, that leads right into the notification. That's what I think. If he takes the time and effort to write the warning, then they should be notified.
Well, something you guys gotta think about.
Yes, I'm thinking.
Do you want to vote on whether we should do?
Well, my vote's to be notification based on the first written warning. That's my
Then
position.
it's not a warning.
Will be notice to the person's probation officer,
And
right?
that- and they'll ferret out, I think,
It says written warning and
extenuating
notification.
circumstances before they take action.
Because just being present in one of these zones doesn't
It's not an
automatically mean you
infraction.
violate probation, right?
right.
Yeah.
So, what's the question? Did you, okay, Dwayne would like to do it under the warning
Right.
Warning or infraction.
or infraction?
Yes.
What, warning or infraction?
If it's a warning, it's not an infraction. If it's a warning, it's a warning. It's a verbal warning.
No,
Whereas,
it's actually a written warning.
okay, if they're getting a written warning, then that's the first warning. and they don't get an infraction until it's the second time.
No, the notification to the probation officer.
Okay,
Should
now,
it go under a warning or under the, when they get the
I
infraction?
want it to go under a warning.
Dwayne, you said?
I said morning also.
Okay, warning, okay, we're all in agreement on that. Okay, now we'll go back to our main motion. Is everybody all set there? Okay, all in favor?
Aye.
Aye.
I make a motion to adjourn.